It would be difficult to estimate that, but I can tell you from Arkansas, which is a small state, we employ anywhere from 375 to 400 people. We have expenditures of over $50 million a year. And even though we do operate state programs in addition to the federal programs, if EPA came in, they would have to pick up those state programs, such as landfills. You can't leave landfills unregulated. So they would have to pick up beyond what they're currently overseeing.
So you basically, lots of boots on the ground and lots of expertise.
Yes, sir, absolutely. It would be a tremendous, massive effort and change in the federal organization.
Thank you. Thank you so much. And now I would like to move to a couple of questions for Ms. Steers. Some have argued that states use variances as a, quote, cop-out for enforcing strict environmental standards in the states. Do you agree with that, Mr. Steers?
No, I do not. I think that variances are necessary.
And if you don't mind, we'd also just explain what they are, how that works.
Okay.
And
sure. Variances are a regulatory process that states use in order to adapt local conditions and site-specific risks that may be present that the regulations may not account for, and the ability to allow facilities to operate at a different standard based on those local conditions. Variances are not a cop-out, and they're used, they're taken seriously by the states in as much as they're needed in order to look at the differences of way that regulation is applied across the country. For example, groundwater protection standards and how we regulate groundwater in the eastern part of the United States around the landfill where there may be shallow aquifers is not necessarily the same as you would have out west or in the desert where groundwater may be several hundred feet below the surface. And so you need to be able to take into account the local geologic conditions when you're applying a one-size-fits-all national standard.
so that basically is what you're talking about when you say variances.
Variances, yes.
Exactly. But thank you very much. My remaining time, I'd like to conclude with one question for Mr. Pillsbury. Your testimony talks about tailoring of federal regulations. This doesn't mean compromising water quality for consumers in that state, does it?
No, it certainly does not. The ultimate compliance with whatever the regulation is the compliance that we achieve. There is, in implementing pretty much any national regulation, some discretion on the part of the states about how best to do that, given local circumstances. So that's really what I meant by saying tailoring, to make it so that it's as practical to implement as possible.
Can you tell me the difference in tailoring and variances? Is there a distinct difference there?
Well, variance, I think, is an actual term that's used in the rules and regulations. And so tailoring is more of a concept of making a national standard fit within your state and how best to implement it, how best to train people, what kind of capabilities they're going to need to be able to meet compliance. So we don't really do variances in the drinking water program that are allowed by statute, but we do a lot of tailoring to get the job done.
I understand. Thank all three of you. Mr. Chairman, I'll yield back.
Gentleman yields back his time. Chair recognizes the gentleman from California, Mr. McNerney, for 5 minutes.
Well, I think the chairman and I want to congratulate you for your elevation and selection, and I look forward to working with you on a bipartisan basis to solving some of the problems that we're facing in this committee. I found the testimony on fracking, Mr. Fitch and Mr. Lepore, very informative, so thank you for coming, as all the witnesses. One of the questions that I have that's sort of ongoing about fracking is how important is complete transparency to public acceptance of fracking in local communities?
I think transparency is a crucial element in the whole debate there. There's a lot of misunderstanding, frankly, on the part of the public about what fracking is and what the potential impacts are. There's a lot of suspicion about the chemicals that are used. I think it's important for the states to get that information out there. In Michigan, we're going all over the state, my staff and I, giving presentations to kind of try to get the facts out there and hear people's concerns.
Mr. Lepore?
I would agree with Mr. Fitch's comments. Transparency is critical. Building trust with our community members is critical. Imparting information is critical and is a huge challenge. I use one example. I think the term fracking has been used widely as sort of a substitute for all things oil and gas, and it's an ongoing challenge to try to parse those distinctions. But
I mean, to me like disclosure is something that the federal government could impose as an requirement on fracking nationwide. I mean, there's differences in terms of geologic formations, but disclosure is something that should be universal in all fracking requirements. Would you agree with that?
Obviously, Colorado has made the decision that disclosure is important, and it was a long and lengthy conversation in Colorado. It started in 2008. There were a lot of concerns by operators with respect to trade secrets in particular, and I think Frac Focus is a tremendous tool that's available to all states. I think it's in operators' best interest, to be quite frank, to disclose the chemicals they use in frac fluids.
Good, I agree. Like Colorado, California, my home state, is water bound. I mean, we always have to worry about our water sources. And one of the concerns I have about fracking is the amount of water that's used and what happens to that water after it's used. Is it reclaimed? Is it discarded into local aquifers? Or how do we deal with the water issue in a state like California and Colorado?
When you talk about how much water it takes to frack a well and you talk about several million gallons, it certainly seems like a big number. For the state of Colorado, the amount of water used totally for fracking is we have calculated at less than 1%. The vast majority of our water is used for agriculture. That said, again, I would say that reclaiming and recycling and reusing that water is becoming an entrepreneur's dream. There's a huge need to do that, and we are approached fairly regularly now, we, the Colorado Oil and Gas Conservation Commission, from businesses interested in instituting on-site recycling and reclamation and asking us questions about how that would be regulated and so forth. So it is an important issue. It's going to continue to be an important part of the discussion, and we should encourage as much reuse as we can.
So that's an area for innovation then?
Yes, sir.
Recycling and recovering. What about the water that's just discarded after fracking? I mean, is some of the water that's recovered just discarded into the aquifer, or how is that managed?
That so-called flowback water has to be handled carefully because it does have some, it may have some remnant contaminants in it from the hydraulic fracturing additives, and it may also be picking up salts and compounds from that target formation. In Michigan, it all has to be contained in steel tanks and injected into deep injection wells. And most states have similar methods for dealing with it.
And so that's part of the transparency, is how that wastewater is finally disposed of. That would have to be part of the transparency.
Yes. Mm-hmm.
Okay.
I think the disposal question, too, is one which highlights what we're talking about today, which are the differences regionally or locally. In Colorado, like Michigan, most of our exploration and production waste, when it is exhausted, is injected into deep disposal wells. Other states use different disposal methods depending on the geology and topography and so forth, including discharge to surface streams. So they have to deal with the waste the way that works for them.
Thank you. Mr. Chairman, I yield back.
Gentleman yields back. Just for notification of how we're going to operate, we're going to try to finish 10 more minutes of questioning. The two Texans, Mr. Barton will be next, and Mr. Green. I think Mr. Green and I have just agreed to be the last guys out of here to hit the floor to vote. If we'd like to come back after the votes for those who still want to ask questions. And with that, I recognize Mr. Barton for 5 minutes.
Thank you, Mr. Chairman. I've listened to all the testimony and the questions that have been asked so far, and I want to go back to the purpose of the hearing, the role of the states in protecting the environment. That's the title of this hearing. As I read the Constitution, it starts with the three words, we the people, which means the power comes from God to the people. The people delegate some of that power to the states. states delegate some of their power to the federal government. And then the 10th Amendment says that all powers that are not explicitly enumerated in the Constitution reserved for the states or the people respectively. As is pointed out by the witness from Arkansas who represents all the states, as I understand her role, the states are doing most of the work in actual environmental protection on a day-to-day basis. They use some federal law and, of course, their state laws to do it. So the issue that before the subcommittee and this panel is really who's going to set the policy? Who's best able to set the policy? Is it the federal government, top down, or is it the people in the states, bottom up? And I listened, and with the exception of the gentlelady from North Carolina, I didn't hear too much complaint about the states being able to set the policy. Now, I want to ask the gentleman from Colorado, do you think the federal government is better able to set the policy in your state than you and the legislature and the people of Colorado?
No, sir, I don't think so. I think that we have had a successful oil and gas commission in the state for 60 years that understands the distinctions, not only Colorado versus other states, but in our different oil and gas producing basins. We have coal bed methane, we have Niobrara shale, we have a variety of different geologies. We have a 60-year history of rules that have evolved over time as our understanding and technology have evolved. So I think the Oil and Gas Commission is perfectly capable of setting policy. I think there is a role for the federal government in research and other things that are a little bit beyond our reach in terms of the ability to finance those kinds of projects. But I think the states are doing a fine job.
As I understand the process in Colorado, these state regulations that have just been promulgated are the result of a process. There was a lot of stakeholder interaction, a lot of involvement with the people and the legislature and the industries, and it kind of evolved, and finally either there was a regulation issued by your agency or a law passed by the state of Colorado that you're implementing. Is that correct?
That's correct, sir. What we adopted are rules of the agency that the commission itself adopted pursuant to our statutory authority. The stakeholder process for the setback rules in particular was a year long, about 11 separate stakeholder meetings over a period of 7 months, and then we moved into more formal rulemaking. We had representatives from industry, of course, from environmental groups, from groups like home builders, agricultural interests, very, very diverse. So everybody had an opportunity to be heard. Not everybody's totally happy, but everybody had input, and you've got a set of regulations now that seems to be working and it seems to be successful. Is that a fair statement? That's a fair statement. I might add that I don't think anybody was totally happy, but yes. Now, the gentleman next to you, Mr. Fitch, represents the Interstate Oil and Gas Compact Commission, which is a voluntary association of state regulators and state governments. Is that not correct?
That's correct, sir.
And you have provided technical information to any state wishes on the various technical aspects of hydraulic fracturing, and in doing that, you have been able to use some research from various universities like mine, Texas A&M, that could give the states a technical basis on which to base their regulations. Is that not correct?
That's correct. That's one of the great benefits of IOGCC, that ability to share information and coordinate between the states.
Now, is anybody complaining that that process is flawed or broken?
No, sir. It's been very effective.
Mr. Chairman, I'm going to yield back, but it would appear to me that the current law gives the states great flexibility, great opportunity. They can get research money and technical assistance from a number of sources, including the federal EPA, but the basic policy decisions on these issues appear to me to be best made at the state, and the state seems to be using those authorities. If Colorado is any example, in a very fair and effective process. With that, I yield back.
Gentleman yields back the time. Chair recognizes the gentleman from Texas, Mr. Green, for 5 minutes. The former ranking member of this committee. Noted.
When am I going to get my picture put up, Mr. Chairman? Thank you, Mr. Chairman. I appreciate the panel and the questions. We conveniently hear how that uniform federal standards are necessary whenever federal legislators want to override state actions. However, isn't it accurate to describe that most federal environmental laws as creating a broad, overarching federal framework while delegating to the states the responsibility of creating specific regulations that reflect the realities of circumstances that differ in each state that may require different approaches? And if you can't tell, I'm from Texas also and served 20 years in the legislature. And, of course, we always have complaints about EPA, but we also know that our Texas Environmental Quality Commission and EPA work out the relationship that they have so the permits are issued, except now in carbon. But is that generally from the state experience?
Yeah, I would say so. A lot of the states, including Michigan, had environmental regulations on the books before some of the major federal legislation. So it's not like we've been lagging behind. But I think some of the federal legislation did establish kind of a threshold or a standard that applies across the states to it. So it does encourage some consistency.
But in every case I can think of, it's a partnership, though, between EPA and the local state regulator in actually issuing permits and enforcing it.
Yes, it is.
Okay. Mr. Finch, much has been discussed regarding the state's role in regulating oil and gas, natural gas development and production in the process of hydrofracking. In some cases, hydrofracking has taken place in states that aren't traditionally viewed as oil and gas producing states, and I'll give you an example. We've fracked in Texas for, I guess, 30 years. Of course, the success now is because, you know, first Barnett Shale, Eagle Ford, and even in West Texas now reopening what the Permian Basin. But in example, Pennsylvania has actually done some things locally that Texas actually followed Pennsylvania's lead on. One, in the release of the at least a lot of the information that's in the fluid. Is there a program available to states to review their state regulatory programs and assess what's currently on the books between the interstate compact?
Yes, the IGCC does perform that function. And the Groundwater Protection Council has a peer review program for the underground ejection program also that, you know, other states come in and compare against standards so that to assure some consistency.
Do you know which is stronger? How many state reviews have there been done?
By stronger, we've done about 6 or 7 just on hydraulic fracturing. I think the states with probably about 90%, accounting for 90% of the production, have undergone an overall state review.
Is there a separate review available for states for hydraulic fracking or fracturing?
I'm sorry?
Is there a separate review available for states for hydraulic fracking?
Stronger, by the way, is the state review of oil and natural gas environmental regulations. They do have a module for hydraulic fracturing. The IOGCC does, I mean, we have kind of an informal system, and they also have an inspector certification program that will help assure that state inspectors are qualified and capable.
I have some information that says Stronger has been completed specific hydrofracking reviews for Arkansas, Colorado, Louisiana, Oklahoma, North Carolina, Pennsylvania, and Ohio. In each of these reviews, have they had a critical assessment, and is that available to other states who may also be experiencing an expansion of hydrofracturing?
Yes, there's a report made on each of those reviews, and it's available on the Stronger website.
Okay. Thank you, Mr. Chairman. I'll give you back 49 seconds.
And I will take that for you and make an announcement that we will recess and return approximately 10 minutes after the last vote is called, which should give you time to get a little boys or girls break, maybe a soda or a sandwich, but we'll reconvene about 10 minutes after the vote.
big font and double space next time.
That Jim did that for me.
I often forget to do that, and when I remember it, I'm like, oh, that's a good idea.
You all right? You know, you don't really know. This all comes streaming out.
Oh, Ann, yes.
Yeah, you kind of catch the tenor of both sides of the trailer. Public outreach.
Hi, Kat. How are you?
Really bring people together. It's one of those partnerships.
You? Fun stuff.
Kind of elevated in her position, taking on more
So
responsibility.
you're covering this for your...
That happens when you have good people.
Yeah.
Nice meeting you.
Testing.
Try again.
Testing.
I don't know where he's feeding it from. Oops.
Check. 1, 2. 1, 2.
Three, two, one.
That works? It works. All right.
Let me call the hearing back to order, and before there's a couple pieces of business I want to make sure I accomplish. I ask unanimous consent that all members be given 5 days for opening statements that will be submitted as part of the record. Without objection, so ordered. And with that, we'll thank you for coming back. Hopefully you got a chance to take a break. I didn't get my soda or candy bar, so I'm a little grouchy. But they're used to that in this committee, so I'm in good shape. So with that, I'd like to see no other members present. Mr. McKinley is recognized for 5 minutes for his round of questions.
Thank you, Mr. Chairman. I heard earlier it was going to be quite a few minutes before, but I'll go with it now. Thank you very much. I have questions of Ms. Harris, if I could, please. If you get your mic on
yes,
close, okay. I was one of the sponsors of the bill on the fly ash legislation, so let's just start with that, if you would. Have you read both of the bills?
I've read some summaries of them.
Okay. Could you summarize the difference between the two bills?
I'm not sure between the Senate and the House bills.
No, between the House bills that passed, the Senate never taken one.
Oh, I'm sorry. Okay. No, sir. Then I haven't read both of them. And I'm not familiar enough to summarize the differences.
Okay, because you made quite a bit in your written presentation about your knowledge of it, but you're saying you've not even read the bill and you don't know the difference between the two. Thank you. That's do you acknowledge that does the EPA have the expertise to deal with fly ash?
Well, I think my position.
Kind of a yes or no.
I think they're in a better position than we are to deal with
and that's
flash.
Fine.
And that was my point.
So, if they have the expertise, and they've made some determinations about fly ash over the last few years, I'm just curious. Do you disagree with their reports? You're familiar, they've done 2 reports on fly ash, are you not?
Well, I'm familiar that they've done the reports. I'm not sure I'm intimately familiar with the details of those reports.
Interesting. They've done 2 reports, and both times the EPA has said it's not a hazardous material. So by your statements in your testimony are based on what fact?
Based on, actually,
do you have the educational background, science background to differ with them on this? If the EPA has said it's okay.
Right, yeah. No, I submitted with my testimony. We've had some pretty significant research that's taken place at Duke University, and that study that was released and attached to my testimony.
No, my question, how did you differ from the EPA's own determination? They've done it in 93 and 2000. Both times they said, EPA, that the fly ash is not a hazardous material and it should be continued to be recycled. It's a way of taking care of the product. So if you're differing from that, I'm just curious, on what scientific basis are you saying the EPA is wrong?
As I mentioned, thank you for that question. As I mentioned, we've had some scientific studies that have been undertaken in North Carolina by Duke University. Dr. Vengosh, I included it in my testimony, and it shows contamination from seepages from some of these coal ash ponds.
Okay. The material, I think one of the material differences is that the opponents of the legislation, and we passed it 4 times out of the House, is that they did not want, the people in the House did not want the EPA to have primacy, and they wanted to retain that control with the state legislatures, state government groups. Now, are you saying that North Carolina doesn't have the expertise to handle fly ash?
Yes, sir. That's been my experience with working with our agencies and working with the legislature and to try and get a better, safer regulatory regime for coal ash. I don't feel like we have good regulations in place.
Okay. Do you know that well, you've acknowledged that you haven't even read the bill and you don't know the differences. You know in the bill one of the major differences was that we listened to people like you, and we had put language into the bill to deal with the disposal of fly ash that heretofore is not current law. And for you in North Carolina, it gave you the ability in North Carolina to call for liners under new impoundments. So we're trying, and the EPA, and furthermore, that if the EPA determines that you in North Carolina are not following those standards, they can seize the landfill and take it over primacy themselves. So by virtue of what you're saying, you were having a problem that you thought that with the legislation, it actually was intended to help you in North Carolina and any other state that has some degree or lack thereof of how to dispose of fly ash. So I'm really troubled by your remarks, particularly your written testimony, and I appreciate what you're saying. Fortunately we've run over time, but thank you, because you've explained a little bit about why you've taken the position you've had. Thank you very much.
Well, I appreciate that. I think a lot of my remarks were driven by the findings of the CRS report, and I think they found significant shortcomings with the bill, and I think I was basing my testimony on that, the CRS report. Thank you.
Okay, so you're in opposition to what the Environmental Council of States, one of the more well-recognized groups around the country, that they were supporting the Association of States and Territorial Solid Waste Disposal. So many people all came together, the stakeholders, to make this bill possible. And you're saying they were wrong. I find that curious. Thank you very much. Sorry, yield back my time.
Gentleman's time's expired. Just for comedy and appreciation for the committee, not everyone has a lot of scientific expert. I definitely don't. I understand legislators trying to be involved, and I'm a big coal ash supporter. We appreciate you being here and your testimony. I want to do a couple more pieces of business. Unanimous consent to include statements from 7 environmental groups dated February 15, 2013. A statement from Patrick Parenteau, P-A-R-E-N-T-E-A-U, and a statement from Susan Bodine. For the record, without objection, so ordered. We still have the chair. Is Ms. Bilarkis, you prepared to ask questions? Chair recognizes the gentleman from Florida for 5 minutes.
Thanks so much. Appreciate it. Chairman Shinkus and Ranking Member Tonko, I'm honored, of course, to have the opportunity to represent Florida's congressional district, 12th congressional district, 12 now, on the committee. I look forward to working with you. Thank you for giving me the opportunity to serve on this committee. Ms. Marks, you have spoken about the delegation process and the importance of respect between the federal and local agencies responsible for protecting the public. Unfortunately, this relationship does not always live up to our ideals. For example, the EPA issued an America nutrient criteria for Florida to avoid litigation with environmental groups, and in the process circumvented the state's reasonable and scientifically based efforts to address its water quality. That rule was based on flawed science, had no consideration for the harm it would inflict on Florida jobs, particularly in agriculture, and was a threat to other states' rights to self-regulate. Considering the EPA's recent agenda, what are some of the examples of specific steps that Congress can take to ensure that state and local governments are able to compete with federal agencies on a level playing field when disputes over federal regulations are called into question? Thank you.
Thank you, Congressman. I'm not sure that I can tell you what type of specific statutes might be passed or anything to that effect. I can tell you that we certainly are concerned that cooperation with the states be encouraged at every point, that there be full disclosure with the states. We would like to be in on the rulemaking process at an earlier time, and we would like to certainly be in on the guidance that's issued with these rules. There have been times, I think, where guidance has been issued that has not adequately taken into account the effects that it will have, particularly the resources it will drain from the states. So we would like to work with EPA, and I don't know if statute would be necessary in that regard.
Well, any steps, exactly, not
we would like
necessarily
we would like to work with EPA and have EPA encouraged to work with us on getting us involved early in the adoption of rules and in the guidelines to implement those rules.
Very good. Anyone else on the panel wish to comment? Well, thank you very much, Mr. Chairman. Appreciate it. I yield back the balance of my time.
Gentleman yields back his time. Chair recognizes the gentlelady from Colorado, Mr. Gett, for 5 minutes.
Thank you very much, Mr. Chairman. For those of you who don't know, I've been working on a bill called the FRAC Act since 2006. And what this bill basically does is it says, just like every other industry or activity that puts substances into drinking water, the oil and gas industry should be subject to the requirements of the Safe Drinking Water Act. Now, as you all know and we know, what the Safe Drinking Water Act does is it establishes baseline requirements for underground injection control, but then states may set stricter standards, and also the EPA works with states to make sure that they promulgate regulations that are unique and work for those states. So, for example, if you have a state like my state of Colorado or Pennsylvania or North Carolina or California or New York or any of these other states that are doing hydraulic fracturing, the geological issues are different in all of those states. The depth of the wells is different in all of those states. So the Safe Drinking Water Act wouldn't put a cookie cutter process into place. What it would simply do is say you have to meet a minimum requirement for the chemicals that are being injected into that ground, and you have to have a national, a readily accessible disclosure scheme. And frankly, a couple of years ago, the industry and I were this close to being able to come up with a agreed upon reporting scheme that would not be overly onerous, but would allow consumers to see what chemicals were going into their drinking water. I'm getting ready to reintroduce that bill again next month, and I want to ask a couple of questions around that. First of all, Mr. Lepore, since you're my guy from Colorado, and I'm so proud of the work that your agency has done, Colorado, you would say we're really in the vanguard of the states that have enact rules around fracking and natural gas development, correct?
Yes, I would.
And that's one reason is because, as you said, we've been doing natural gas and oil in Colorado for over 100 years, right?
Yes.
Now, Representative Harrison, in your state, you said you only just started fracking, and you really don't have a regulatory scheme, right? Is that correct?
Right. Actually, we haven't actually started fracking. We lifted the ban on fracking and are anticipating permitting in the next year or two.
So you have absolutely no regulatory history on hydraulic fracturing, and this is particularly true with fracking, Mr. Chairman, because it's a technique that has been found to use in all types of formations, whereas before some of the traditional techniques were not economically feasible to use all around the country. So Mr. Lepore, I wanted to ask you if we have widely ranging techniques and formations and state regulatory frameworks, I'm going to assume that you and your association wouldn't disagree if there was a federal disclosure rule that was sort of a baseline rule, so long as the EPA worked with states and states could adapt that to their own needs, correct?
With the caveat that the devil is in the details.
Well, obviously, but I mean the general concept. You don't disagree with that, right?
The general concept of disclosure, I do not disagree with.
Okay, and let me ask you another question. In your written testimony, you said that the Colorado Commission prides itself on oil and gas development tailored to the needs of specific basins, environments, and communities. Do you think that further flexibility is needed for development on split estate lands?
Split mineral and surface estate land?
Yeah.
I think that's why we have the rules that we have and why we've just gone through the setback.
So you would say yes, local consultation is necessary to do that?
With local governments?
Yeah.
I think engaging with local governments is very important.
It's critical, right?
Yes.
Thanks. One more thing I wanted to ask you about this reporting under FRAC Focus is that how many states are requiring disclosure of FRAC fluid components through FRAC Focus?
I'm getting two different answers.
Mr. Fitch, do you know the answer to that?
I believe the answer is 10 or 13.
Okay.
13.
And is it required disclosure through FRAC Focus? Or is it voluntary disclosure?
Required by statute or rule.
In all of those states? Yes. Okay. The audience member is nodding yes. So that's about 10 or 12 states, correct? Maybe Mr. Fitch or Mr. Lepore, you can supplement your testimony and give me a list of those states. I'm sure my staff knows, but I don't know off the top of my head. One last thing I wanted to one last thing I wanted to ask is the EPA study on the fracking is coming out next year, and once that happens, then we're going to all sit down, and I hope that you will come and help us work this out to see what the appropriate regulatory framework will be, because I think the states and the federal government really need to work together on this issue. Thank you for your commentary, Mr. Chairman.
The gentlelady yields back her time. Chair now recognizes the ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. We've heard today from some of the witnesses that we can rely upon the states or members. We can rely on the states to protect the public health and environment, and therefore a reduced federal role is appropriate. But the states' track records are not flawless. For example, sea level rise is an undisputed consequence of warming climate. Many states are dealing with this challenge, but the response is not uniform. For example, the scientists on North Carolina's Coastal Resource Commission recently concluded that North Carolina could see a sea level rise of more than 3 feet by the end of the century. This is critically important information for coastal development decisions, but the information wasn't consistent with the ideology of some in the General Assembly. Representative Harrison, are you familiar with what happened in the General Assembly, and could you tell us about it?
Yes, sir, I am. It was rather a black mark in the history of our legislature, I think. What happened was, under pressure from developers in the communities on the coast, legislation that was introduced that would have banned the calculation of sea level rise to factor in climate change and acceleration from thermal expansion and melting glaciers. So rather than factoring in a trajectory of about a meter sea level rise over the next century, the legislation would in fact limit us to anticipated 8-inch level rise in sea level rise. We're particularly vulnerable in North Carolina because of our 4,000 plus miles of shoreline and the low-lying areas near the shoreline. So this was a real problem for folks who are trying to have a better adaptation strategy like theirs.
The bill that was introduced would have precluded the Commission from planning for anything other than 8 inches of sea level rise. Is that right?
Yes, sir.
And after enduring public ridicule, the legislature succeeded in blocking the Coastal Resources Commission from estimating rates of sea level change until July 1, 2016. Is that right?
Yes, sir.
Okay. Well, in your view, was this policy a policy that ensures North Carolina makes the best decision possible about its coastal development?
I think it's sort of reflective of the current attitude of the legislature that they're not doing what's best for the state or its resources.
Well, states play a critical role in environmental protection, but they don't always get it right. And in some cases, as in North Carolina example, state legislatures have proposed or passed bills to tie the hands of the state regulators, whose job it is to protect the environment and public health. Another example is South Dakota, and numerous other states have laws on the books as well that prohibit the state agencies from taking any actions that are more protective than rules adopted by the federal government. In Ohio, the state environmental agency is blocked from setting air quality standards that are more stringent than the federal standards. Those are just a few examples. state regulators may have the best interests of public health and environment at heart, but they can only do what their legislatures authorize them to do. I assume that, do any of the witnesses disagree that an agency can't take action if their state legislatures enact a law that blocks them from doing so? Does anybody disagree with that? That's just the reality. While some here may believe that state regulators will always be better than federal regulators in protecting the local environment, we have to remember this important lesson. Polluters are fighting hard at the state level, as they do at the federal level, to block or weaken meaningful safeguards. And that's why it makes sense to set a federal floor of protection for environmental laws so that all Americans are guaranteed a minimum baseline of protection. I wanted to bring out that point, and thank you, Mr. Chairman. I'll yield back the balance of my time.
Gentleman yields back his time. Seeing no other members present, Mr. Tonko, you wish to be recognized?
Yeah, Mr. Chair, just briefly, and I appreciated the comments you offered on behalf of the subcommittee concerning the cross-examination of our witness, Representative Harrison. But I'm compelled to state that, you know, the representative was invited here to speak as a legislator on behalf of the National Caucus of Environmental Legislators. She cited a scientific review or study done by others. And I thought that the cross-examination just didn't respect this panel and its sacrifice in whatever dimension to be here today. Their role is to inform us and to share their opinions. And I found that being treated as a scientist, which I don't know her resume, but she was here as a legislator. And, you know, to begin with, 2273 had passed the House, but 1391 wasn't even released from committee. And, again, I just feel it's important for us to stay focused on the perspective that was being shared at the table by our witnesses, and we show due respect when we conduct ourselves that way. So I was very concerned about the cross-examination by the gentleman from West Virginia. With that, I yield back.
Gentleman yields back his time, and I appreciate the comments. And I would just hope that as we move forward, that the same concern expressed on this exchange will be the same expressed on the other side once there's other interchanges that will occur, because we're a big, powerful committee here in Washington. We have divergent views, and we fight like cats and dogs. We can agree to disagree respectfully, and I think that's the point being made. We'll do our utmost to try to do that. We do thank you. Great testimony. We appreciate you coming here. Thanks for staying through lunch so that everyone had a chance to come and ask their questions. And with that, I will look at what he's saying here. Thank you. You may get a few questions for the record submitted by members who were here or even were not here but are members of the committee. If you would get those back to us as promptly as possible. I think our rules say, do we give a set time? We have no idea. So try to do it as soon as possible. We appreciate it. With that, I will adjourn the hearing.